The 18th of November 2023, here from rural Ireland, real true education, not fake news. It's a wet, not too cold, but very wet, ugly, kind of a mucky day after a lot of rain. Now, I'm dealing here with the Pylons number part 3, and I want to get this dealt with so that there'll be a block of videos right alongside each other, hopefully, where the person can go in and look at them at any time, and so I can move ahead and get away from this subject and leave it there for whatever action may be taken. I've solved a lot of problems throughout my lifetime, and generally I start by analysing the problem, writing down what it is, what the cure is, and leaving that either to implement it myself. If I implement it myself, I generally always win in most circumstances. If somebody else has to implement it, then they have something to go on, and that's another way of doing it. We're going to take a look at one of the core aspects of this, how I would go about tackling this now. And this is it here, Regulation 347 of 2013. Now, I will have no part or act in the way some people may approach any court case, and there's a lot of money involved, so I have to issue the usual disclaimer and tell you I can't be held responsible for how this information is used. And indeed, my opinion is given in the best of faith, but I cannot take responsibility. I'm not your lawyer. If we're getting lawyers, that day will come. Now, I'll go back to you here again. Regulation 347 2013. There it's there in case there's any doubt, right? One of the things about what I'm doing is they expect you to, some people who are against you mainly, expect you to prove every little point and every little comma. That's how they fight you. And then they find a spelling different and they come after you on that. This is the way it works. Now, this regulation was issued on the 17th of April 2013. There it is again now. There shouldn't be any need to show it to you anymore. And that's it. It's a regulation. Now, a regulation differs from a directive, and the directive has to be implemented at state level, whereas the regulation comes in with the day it's signed. The regulation comes in on the day it's signed. Now, we're going to look at it here. Here you can get it here, and I will be posting a link underneath. And here it is here. You mightn't be able to read this. You can search for it. I'll post a link, and this is it. Now, when you're looking up any EU law, you never, ever look at the interpretation from any government, from the EU Commission, or anybody else. You go to the regulation or the directive itself. And it will have a preamble which is persuasive as to the interpretation of the articles, and then it will have the articles, usually no more than 12 articles, and those articles are legally binding. There is no ifs or buts about them. That's it. EU law takes precedence over all Irish law, whether the Irish government likes it or whether they don't like it. That's the law. Now, we're going to take a look at it, and you go to the how do you know you have the right? Well, if you see EU Lex, I don't know, can you see the corner of this? I don't know, can you see it there? But if you see the word LEX, that is usually the good indication. LEX is generally a good indication that you're on the right track. Otherwise, you're reading out baloney opinion, citizens' advice, and maybe the advice of a firm of solicitors. You go to the source of the fountain, the EU regulation or the EU directive. That is it. Right? Now, so we look down through it, and the first thing you get in any of these is a preamble. And the preamble sets out why they're doing it, what the reason behind it is, and this is all to do with all this energy coordination, having a one grid all over the place and all of this. You can read that yourself. If I were to read it here, we'd be here all week, right? So there was proposals made, and there was this, that, and the other, and it goes on down there to say all the wonderful things and how they're so accelerating the refurbishment of existing energy infrastructure, and the development of new energy infrastructure is vital to achieve European Union's energy and climate objectives. That's their opinion, right? So objectives, right? You have that there. So you can read all that down yourself, and if you don't want to read it, don't bother. That's my advice. Now, the next thing is, we go now to Article 2020, we go to Article 31, and here is the only reference there is, but this is very important, and I'm going to read it out to you now. So you go to Article 31 of the Preamble. It's Preamble 31. In fact, the right way of stating this is Preamble 31. It's not an article, it's a Preamble 31. And here we go. The correct and coordinated implementation of the EIA Directive 2011/92 EC is the EIA Directive of the European Parliament and Council of the 30th of December 2011, not relevant, that's it, the EIA Directive, on the assessment of the effects of certain public and private projects on the environment. That's one. Now there's a comma. A comma. I'm sure all knows what a comma is. It's comma, right? Of Directive 2001/42 EC of the European Parliament and of the Council on the 27th of June 2001 on the assessment on the effects of certain plans and programmes on the environment. And there's 16 is a reference underneath. That's the SEA Directive. So what the article says so far is the EIA Directive and the SEA Directive, okay, where applicable. Where applicable. Now, so, of the convention and now, comma. Now, next thing is and, or a comma. Where applicable. This doesn't apply to the foregoing. This applies to what comes after it. Where applicable. Of the convention on access to information, public participation and decision making, and access to justice in environmental matters. Signed on the 25th of June 1998. And of the ESPO Convention on the impact of assessment of transboundary context of the ESPO Convention. Should. Now, we're only talking about two things here for the moment anyway, because there's no point me giving a big long legal argument if nobody's going to bother their head working on it. The EIA Directive for projects at local level and the SEA Directive for the government plans and programmes, and that includes for energy, fisheries, forestry, agriculture, town and country planning, river basin management, energies in there, so they're caught under that. So what this article is saying, the EIA Directive, the SEA Directive and the EIA Directive, the strategic overarching directive and the local one for the project, what does it do? What are they saying here? Now, so should, S-H-O-U-L-D, S-H-O-U-L-D, I spelt it twice, that's adequate. Ensure the harmonisation of the main principles for the assessment of environmental effects, including a cross-border context. So it should. So what should it do again? It should ensure the harmonisation of the main principles of the assessment of environmental effects, including the cross-border context. Member States should coordinate their assessments for projects of common interest and provide for joint assessments where possible. Member States should be encouraged to exchange best practice and administrative capacity in the permit granting process. That states that the SEA Directive and the EIA Directive are a prerequisite. In other words, they're assuming that's there. If you get into a taxi in Ireland, you don't ask the driver, has he insurance? The whole law is all based around ensuring that he has insurance. It's all checked by the licensing authority. You don't have to ask him that to be covered. If you go into a pub in Ireland and you order a drink, you assume it's a licensed premises, and in some cases it's over the door. If it doesn't have that, it's not a licensed premises, right? Now, you assume it has. Some of them have a notice, some of them don't. So, as a prerequisite to all of this, the word should is in Article 31 is vital to understand, and that's where you need to go. Article 31, it should ensure the harmonisation of the main principles of the assessment of the environmental effects, including the cross-border context. So, there you are. Now, I went to court on this. I only got as far as the High Court because I couldn't go on. I hadn't the resources. I had no one to take notes or anything. So I had one helper, and that's it. Now, so the point about it is I leave the preamble then and you go into the articles. And the article sets out about how it should be done. And how you have a designated planning authority. In this case, that's Bord Pleanála. They were raving on about, or it should be Meath County Council for the North-South Interconnector, the Cavan County Council, the Monaghan. No, it doesn't. It's Bord Pleanála has been designated, and they are entitled to do that. But it makes it more important for a good appeals process after that. If you apply to build a house, you have the planning, you have the local council planning, you have the Bord Pleanála, and then you have the appeal right up through the courts. With this, you only have one hearing, so it makes it more important for them to be exact and to get it right, and it makes it more important for the courts to be allowed to get involved. So it gives you all the definitions. You can read it there yourself. Projects of common interest, it makes it a project of common interest. That's not, I never challenged that. I wouldn't be bothered. People who do that, that's why I'd be afraid to give too much information to groups who won't listen to me, because they'll go off with 16,782 grounds. They'll have that many grounds on the statement of grounds that no one will know where the real ground is. This is what's done. If somebody wants to be malicious and defeat this, that's the best way to do it. Go into court and put a big heap of grounds. Put 100 grounds on it, or 200. And you swamp the whole system, and when it goes to the European Court of Justice, they have no clear, definitive thing. So it'd be very important, if anyone's going to court on this, that they let me have a say in it, and that'll be what I'll be doing. Right, now, so this deals with gas, electricity as well. Not interested in that. This is not for gas. Now, and there's implementation and monitoring, and they got permission, I think it was in the end of 2015, early 16. So they really have a problem because COVID blocked them. And now they have to get it done in 2 years. So in the new year, I see an unbelievable rush. Now, it's up to my viewers and those involved to decide what to do with NEP. I have no doubt NEP will help you protest. They'll probably provide caravans. They'll probably have some money there. I was at a meeting of theirs where they asked for €2,000 per household, per farmland or household, all along the route. I mean, this would do this case of mine 10 times over. We don't need 2,000 a house. If you got, I'd say, I don't know what to be, but I'd say we're talking here about 6,000 to 60,000, €60,000 to start off, and you might need a bit more if it goes to the higher courts. It should be easy enough collected after that, right? So if every house contributed 500, it wouldn't be too bad. But it has to be handled by somebody who is going to do it right. The legal team has to be spot on. There are a few lawyers in the country that know how to handle this and have been in there and know how to handle them. And there are about a whole heap of others who haven't a clue. And we haven't time to start educating new lawyers. And if any group gets lawyers that are not up to the job, you might as well waste your sweetness on the desert air. You have nothing to do with them. I'm the best bet at securing the right lawyers. I know a few around. So you have to realise that. So you can go along with NEP for all. They'll supply you with sandwiches and tomato sandwiches and flasks of tea and all that. And off you go with the protesting and all of that stuff. We'll be looking at that in a while, what the real law is on that. But for now, I'm dealing with this. And it goes on there then about the permit granted and public participation. And it says there has to be public participation. Now, what is so important in this to remember, the time for taking judicial reviews is over. It is over, right? So now we look at the revised Planning and Development Act 2020, where, this is section 160, where an unauthorised development has been, is being, or is likely to be carried out or continued, the High Court or the Circuit Court may, it'll be the High Court in this case, on the application of a planning authority or any other person. I'll read it again, I'll spell it. Where an unauthorised development is being or is likely to be carried out or continued, the High Court or the Circuit Court on application of the planning authority or any A-N-Y, other, O-T-H-E-R, P-E-R-S-O-N, any other person. That's as far as I can bring it to get people to understand. Right? Whether or not that person has an interest in the land, whether you have an interest in it or not, by order, require any person to do or not do or cease to do, as the case may be, anything that the High Court considers necessary and specifies in the order to ensure as appropriate anything which the court, it doesn't say High Court, it's higher circuit. In this case, it would be the High Court, followed by the Court of Appeal, followed by the Supreme Court and the European Court of Justice, right? To do or cease to do anything, as the case may be, anything that the court considers necessary and specifies in the order to ensure as appropriate the following: that the unauthorised development is not carried out or continued, B, that's A, B, as in far as is practically that any land is restored, put it back the way it was. Now, the next bit is that any development is carried out in conformity with, as the case of the permission granted, it's performed in accordance with the permission, you'll not be fighting that, you'll be fighting on the fact that it's completely illegal. In the case of a certified by Dublin Docklands, that doesn't apply. In making an order under Section 1 where appropriate, the court may order the carrying out of any works, including any restoration or reconstruction, removal, demolition, altering or any structure or feature. Hopefully, if God spares me health, I'll be doing that for the Rara wind farm and the Tirwalker wind farm in due course, but that's the law there. So the High Court or the Circuit Court for now. So they can put it back the way it was. Subject to 161, an order by an applicant under this section is determined may contain such terms and conditions as to payment for the costs. Now we deal with the costs of this after. Now, as the rules of the court may provide for an order under this section to be made against those identities is unknown. Any relevant rules of the court made in respect of Section 27 inserted by Section 19 of the Act of 1992 of the Act of 1976 shall apply to this section and should be considered. That's only doesn't matter. The application under this section to the Circuit Court shall be made to a judge of the Circuit Court for the court in which the land is situated. If it's the High Court, all land is in their area, and an applicant is situated. We leave the Circuit Court there for the purposes of that. So that's it. Now, in determining whether the price was 3,000, if the project is over 3 million, I have a habit of giving the wrong amount. Where the amount of the pylons is over 3 million, you go to this High Court in Dublin, and it deals with how you calculate that here, common sense really, so the jurisdiction and how you count up the value of the work that's to be done, and so the land in question would be measured in billions. So it's not a problem. You go to the High Court. Now, so that's basically it. They can fight it, and the first thing they will do is they will hit you back with you're launching a collateral attack on the planning permission that was given. You had 8 weeks. There was 2 judicial reviews. You're out of time. That's what they're going to say, and probably the High Court will side with them. The point is that European law is retrospective. The Derrybrine wind farm proved they can make them take it down years after it was done. Court C case C 2419 says that if they're granted in contravention of the SEA Directive, it has to be pulled down. PULLEDDOWL. I find myself having to spell these things to people. I meet people on the street, and I told them all this a month ago. Oh, tell me that again now. And then you end up spelling the words to them. That's the way it's gone. Anyway, just give me a little minute here now, and if I get cut off, that's it. I won't be making this again. Planning and Development Act miscellaneous provisions. Planning and Development Act 2000, it says here. Section 50. Now, Section 50 on its own deals with the right of the planning authorities to take action. That's all right. They're not going to be doing it in this case. What we're looking for here is cost and environmental matters. Section 50B of the Planning and Development Act 2000, and that's inserted by the Miscellaneous Provisions Act of 2011. In this section applies to proceedings of the following kinds: proceeding in the High Court by way of judicial review, or seeking leave to apply for judicial review. Any decision purported to be made, any decision made or purportedly made, any action taken or purportedly taken, any failure to take such action, a provision of Council Directive, the EIA Directive, that's it, the EIA Directive, the Public Participation Directive, of the European Parliament providing participation in certain plans and programmes in environmental amending. Now, and part 2 of section 50B, Directive 20142 EC of the European Parliament of Council on the 27th of June 2001 on the assessment of the effects of certain plans and programmes on the environment. There you are. There, you can't see it. I'll be posting it underneath. That's it. Simple. The SEA Directive. An appeal by way of any appeal in relation to it. Proceedings in the High Court or the Supreme Court. That's a bit technical. The cost of the proceedings or portion of such costs as are appropriate may be awarded to the applicant to the extent that the applicant succeeds in obtaining relief. So if you win, you get all the costs, or any of those costs shall be borne by the respondent and notice party. That's Planola and Airgrid. They have to carry the costs, or both, to the extent that the actions or omissions of the respondent or the notice party or both of them contributed to the applicant obtaining relief. Now that's there because of the likes of myself, the likes of Pat Swords, who forced them to put it there. They didn't put that there voluntarily. Right? Subject to section 2 does not apply to the court's award of costs in favour of a party in a matter of exceptional public importance. This is exceptional public importance, so it should qualify under that as well, but I can't be sure. In this section, reference to the court shall be construed in relation in particular to proceedings under this section applies to the High Court or the Supreme Court as may be appropriate. In this section, statutory provision of the enacted instrument under this section. So what we're looking at there is, now, this is very important. Notwithstanding any portion of such costs as are appropriate, they may be awarded to the applicant to the extent that the applicant succeeds in obtaining relief, that's if you win, and any of those costs shall be borne by the respondent or notice party or both of them to the extent that the actions or omissions of the respondent or notice party or both of them contributed to the costs. Notwithstanding anything contained in Order 99, that's normally if you lose you pay your expenses, pay both expenses of the rules of the Superior Court, and subsections 2A and 3 and 4 in proceedings to which these apply. Each party to the proceedings, including the notice party, shall bear its own costs. Shall bear its own costs. Right? Despite what may be written elsewhere, we made them put in this. They hate it. They're whinging about it. We made them put this in. Notwithstanding anything in the Order 99, that means each party pays its cost if they lose, pays the whole lot. And if they win, if they only get a draw, it's up to the judge, right? Of the court. And subject to the sections 2 and 3 in proceedings to which this section applies. This section applies to a project like the Pylons and to the SEA Directive. Each party to the proceedings, including any notice party, shall bear its own costs. SHALLBERITSOWN costs. That's it, folks. I've said enough on 23 minutes. There is how you deal with it. You have to, the Irish courts, unless you get certain judges, will not hear with you. You must get it all the way to the High Court, to the Supreme Court. In the case of 24/9, in the case of the Friends of the Irish Environment, which I will post here underneath, I think it's C727 of 2023, all 7 judges agreed it had to go to the European Court of Justice. So what you're going to be testing here is, can the EU Commission make a law and put in at the top of it that the SEA Directive shall guide this and shall form the coordinated, and then come along and implement that in a country like Ireland where they did nothing. There's no SEA at all, and the SEA has to be for the whole plan or project. They can't do a bit of it. We're doing it for this. It has to be for energy, full stop. It has to be complete. Can they come along and bypass that in Ireland? Can the European Commission force this through? Can the Irish courts force it through? Can Planola force it through? When the SEA Directive is there, I believe it's a battle of wits between the European Court of Justice which has already ruled always in my favour and this and the favour of what we're saying, and the EU Commission, which says, sure, slip it in there any way you can. And these organisations that are telling you we won't go near the SEA, I wonder why. Why would they not do it? Maybe they're not up to doing it. But whatever the reason is, I have now in 3 videos set out the situation with regard to the North-South interconnector and how I would deal with it. Now, there is also another point. Remember, the planning permission expires about 2026. They accept that the planning permission applies. The planning permission must have a say. Why would they need to apply for planning permission at all? What was the function of the planning permission and the public inquiries if it doesn't need planning permission? The Planning and Development Act is very clear. The directive is very clear. The Irish Minister brought in the SEA Directive, and there you are. Isn't that sticking out like a sore thumb? A sore thumb. It takes a bit of effort. I have now, I think, I might make another video, but you have these now in a group. The North-South interconnector is part of a European-wide project. On the documents under this is, I fought this in the court, there is provision for 600 megawatts of wind energy. They didn't mention the data centres at this stage, but we can see what's happening here is a massive expansion of the electricity supply. Now, all of that has to be assessed under Article 3.2 of the SEA Directive 201/42/EC, or it's illegal. And that is what the Court of Justice of the EU would have to determine. And if you go in and you apply for your injunction, you're unlikely to get it, but you can appeal all the way, and by the time next May comes around, we should have a decision from the Supreme Court either to grant or not grant the injunction. They got their 10 years, they didn't build it yet, and that's up to them. But that's how I would go about it. That's how I would do it at this stage. And if anyone wants to do it, I wish you the very best of luck. I will be hopefully posting underneath here the relevant legislation. You can read it for yourself. What that is, it's not in a nutshell. It's in a walnut shell. It's a big nut, or maybe a coconut shell. And that is the way it works. That's it. That's what I would do. This has never been tested. Can the European Commission and the Irish government and Bord Pleanála and Airbrid overrule the Treaty on the Fundamentals of the European Union? The treaty set up in the Lisbon Treaty and the Aarhus Convention, which is mentioned in here, in this regulation, and the EIA Directive, which is mentioned here, the Habitats Directive, and the SEA Directive. They mention it here. They say this should smooth everything out, but there is none. N-O-N-E. That will be the last of my videos on this. Well, I may have to make bits of others, but until we get movement, I can't do any more. There are a few wee tricks I will not divulge because I don't want to be educating Airbrid. The way a lot of the wind companies did was they waited till they let it in for planning, book sheet, and then they found out all the objections, and then they fine-tuned it and came back again with all the mistakes wiped out, corrected. But they can't get over the fact that there's no SEA for this. And there was an SEA done for offshore wind, and it expired 3 years ago. There was one done, but they can't do a subset until the main one is done. They have to do the overarching one, and they haven't the brains to do that, so you have them caught. That's how you stop the North-South interconnector legally, and that's how I would do it. By the way, while I'm still here, there was a case taken in the North to do it whether the Northern Ireland authorities were in a position to grant this. The court said they did make mistakes, it wasn't quite right, but the court let them off, and he says we're not going to quash it. So any doubt that the Northern Ireland thing is still going on, let that be done. I've checked it, it's not. It's finished. There is no impediment in Northern Ireland to this. You could take this case in Northern Ireland, the SEA Directive applies. In the UK, the same as it does here. That's it. If you have any questions, ask them underneath. I'm done. I'm going on with my day. I've done my best. I've done my duty to people. I do this for people all the time, and I know who wins. The ones wins is the ones that listen up and are genuine about it and dig in and get it done. And the ones that don't are lose. And that's as simple as that. Bye-bye. Give me a thumbs up for my effort. You have to admit I made an effort. And a thumbs down. I seem to be embattled all my life, and I think I enjoy it. That's the story. And get on with the day. I might actually, now that I think of it, do a video on the Electricity Act and this thing about them giving compensation to people to come onto their land. Maybe I better get one of them done. Anyway, I'm away for now. Thank you very much.